Mr. Walsh, thank you very much for the note.
Not at all, my lord. I should just simply explain that it is perhaps shorter than it otherwise would have been if we hadn't sought to try to agree it in more neutral terms. So I hope it covers the relevant principles in adequate detail for your lordships. I'm acutely conscious of time, and I know that the other parties in the Adriatic wish to reply. I indicated yesterday I have 5 or 10 minutes more.
Yep.
I understand my own friend Mr. Nissen would like to make 5 minutes of submissions with the agreement. I think Mr. Selby and Mr. Polly, and then Mr. Selby will reply thereafter.
Yes.
Conscious of that, I wonder whether I might make some very short submissions on Granada, but not take you to any of the passages, but merely give you my submission with the relevant paragraph numbers with it. For the purposes of saving time, and then I'll finish the submissions I was going to make yesterday afternoon.
Yes.
I'm grateful. Well, as you've seen in the note, I commend paragraphs 55 to 74 to your lordships to read, first as to the state of the law on retrospectivity, but also in support of the Secretary of State's case that Section 124 is retrospective, if at all, only to that slight degree. And such a construction is not unfair in all the circumstances. As paragraph 57 of Granada makes clear, and that starts from page 1897 of the authorities bundle, the Adriatic authorities bundle. There's no rigid or mechanistic rule. At paragraph 58, the court recites the well-known passage from Lord Mustall's speech in Sherifian. Then at paragraph 60, the court noted with approval the distinction in Tunnicliffe between legislation which alters the effects of transactions which predated the legislation and liability imposed de novo, which depended on events which had happened in the past. Now, my submission on that is that RCOs are plainly an example of the latter. They didn't exist before the 28th of June 2022, but they can depend on events such as the erection and remediation of buildings with unsafe materials which occurred in the past. And then in paragraph 6, just going back slightly, consider the question at the end about developers and landlords arranging their affairs before the existence of RCOs, to quote from that paragraph, in a way which makes it unfair now to impose a liability based on those past events. That, in my submission, would not be unfair where the mischief of the BSA is directed against developers constructing buildings with fire safety risks. And to anticipate the point about unfairness to landlords, the response to that is mitigated by funding arrangements, as you heard yesterday from me and from my learned friends Mr. Polly and Mr. Nissen. The LPI regulations and indeed their ability to seek RCOs against the responsible parties. So to quote from paragraph 69 of Granada, it may be that your lordships decide that RCOs have an element of retrospectivity, but as part of considering unfairness, you're entitled to place weight upon the purpose of the legislation, and the Secretary of State submits that much more weight should be placed upon the purpose of the legislation, the interest it serves to protect, and the consequences to others of limiting the scope of the RCO power to events which postdate the legislation. That conclusion may be reinforced by the conditions of the new remedy, as it was in Granada, paragraph 71, the fact that liability could only be imposed if the requirements of reasonableness were achieved. RCOs can, of course, only be made if the FTT considers it just and equitable to do so, and the Secretary of State would adopt Mr. Nissen's submissions on to that extent, to which this can be a safeguard. And I know Mr. Nissen may just address you briefly with an additional point, which I also endorse. Now, turning then, leaving Granada, and unless your lordships have any questions, I just was then going to turn yesterday when court rose to deal with the importance of retrospectivity to Section 124. And my learned friend Mr. Selby says it's okay if Section 124 does not apply to costs incurred prior to the 28th of June 2022, because those who paid for remediation works have other remedies. Now, those others would, of course, be leaseholders, and it's through the example of leaseholders that I'll just make the following few submissions. Of course, it will apply to developers and landlords as well. But let us assume Mr. Selby is correct. Well, what about the leaseholders who spent money they perhaps did not have in, for example, 2018 on remediation prior to the commencement of the BSA? What are they to do? My learned friends, it says it's okay because they have remedies under the extended limitation period under section 135, or they can pursue the responsible person through section 149 if, for example, it's a cladding defect. But those causes of action, as my learned friend Mr. Nissen highlighted yesterday with the weight of his experience in such actions, those causes of action to those with limited means, that is leaseholders, whom this legislation is designed to protect, will be required to commence expensive civil litigation to recover sums that they paid under their service charge, if it is to be an RCO to recover those sums. Remember that litigation may not be against their landlord, it's likely to be against a main or a subcontractor. As you heard from Mr. Nissen, those proceedings are complex and they're uncertain. They could be about relatively modest sums in the grand scheme of the works, perhaps £10,000 or £20,000. Very little in the grand scheme, but an enormous amount of money, of course, to an individual lessee, perhaps wiping out their savings. On Mr. Selby's analysis, they are required to launch expensive proceedings to recover those modest sums, as you heard, perhaps in the TCC. It is simply not the policy of the BSA that leaseholders should be required to do so. It cuts across the policy and the overall purpose of the BSA, which is that it is primarily the landlord's role to recover remediation costs further up the chain of responsibility. Or let's assume the Secretary of State and the respondents to this appeal are right, and all the lessees need to do is go to the FTT with, as Mr. Selby concedes, their admirably short waiting times in comparison to the courts, with an application for an RCO to meet the leaseholder's costs incurred in remedying defects relating to relevant buildings. Turning then to the fairness of the retrospectivity, SVDP and Get Living complain at paragraph 99 of their skeleton argument, Triathlon Core Bundle, page 38, that the real unfairness of section 124 having retrospective effect is on the respondents. Paragraph 102 of their skeleton argument says that if the Tribunal's decision on ground 2 is correct, then the FTT can unravel a completed transaction, such as the payment by a leaseholder of service charges from as long ago as 30 years. There is nothing in this point in my submission. As we say in our skeleton argument, I'm not going to repeat it. It's been long the policy of the payment of residential service charge and the legislation underpinning it for about the last half century that it's possible for the FTT to revisit transactions which were considered to be unfair. And the FTT did not consider this was unfair, and they set out their analysis at paragraph 75, Triathlon Core Bundle, page 166, which I won't read out or take your lordships to. This is therefore by no means a novel statutory device for undoing past transactions where it is right to do so. What is the mischief caused by unravelling transactions? What the appellants really mean is the reimbursement of service charges paid by innocent tenants by those responsible for causing building safety defects. And that is the fundamental issue at stake here, because even if the repayment to those tenants, for example, results in a party who was not directly responsible for the defects, paying a sum of money, there is ample opportunity in the relevant provisions of the BSA of the associated subordinate legislation for them to recover those sums elsewhere. There is no inherent unfairness. And in any event, there is a guardrail against any injustice caused by the long limitation period of 30 years built into the language of Section 124, and that is, of course, the just and equitable test. Your Lordships have heard submissions on ground one, but there's no reason why factors such as the landlord's change of position could not be factored in, or why the law underpinning the limitation under Section 27A could be used to assist. I just pause to note also that the term just and equitable was, of course, borrowed from Section 20C, subsection 3 of the Landlord and Tenant Act 1985. So the Tribunal are well used to disposing of cases which involve the application of the test of what is just and reasonable, just and equitable. Excuse me. If on the facts of a particular case it would cause injustice to make an RCO in respect of all or part of the costs incurred, then it is well within the power of the FTT not to make an order, or to make an order only in part. Now, there are similar guardrails in respect of other retrospective legislation, the fully retroactive legislation, to borrow the phrase from some of the cases, in Section 135 and 149, and you see those guardrails in Section 1355, Core Authorities Bundle 51 to 52, and in 1499, Core Authorities Bundle 57, that only allows the court to dismiss an action brought if it would breach the defendant's convention rights. Here, the power of the FTT is much wider than that, and could encompass a breach or an anticipated breach of the respondent's convention rights. I'll just briefly alight on an example that was given in the URS and BDW case about where the convention rights might be engaged, and that is, of course, if the transaction was so old that the respondent had destroyed documents that would have given them a legitimate defence to an action. It doesn't arise on the facts of this case, but there is such, that could be one example where it might not be just and equitable to exercise the jurisdiction. So Section 124 is the guardrail of the BSA or its safety net by which the FTT can mitigate against unfairness arising out of the liabilities that arise under the BSA. The BSA's entire purpose is to recalibrate liabilities arising during the period of 1992 to 2022, which was in a period of acute malpractice and poor industry standards, which was found to be the case by Dame Judith Hackett in her review, and also see the explanatory note to Section 120, paragraph 957, Core Authorities Bundle 385. They are accordingly only made by reference to remedial defects, to defects that occurred during that period, 1992 to 2022. So yes, they are necessarily far-reaching, but it is a one-off intervention. Once again, see the explanatory notes. There will be no more relevant defects post-2022 unless the remediation works are defective. So the class of potentially affected parties is closed. And the ambit of RCOs under Section 124 is plainly aligned with that period of relevant defects. My Lords, those are my submissions, unless I can assist you any further.
Thank you very much. Mr. Nissen.
Yes, thank you. I have four short points largely arising from the material that has come overnight, including the supplemental authorities file, which I hope has landed with you.
I hadn't noticed it, but yes.
Very good. So the first arises from the explanatory notes. The court asked for the life cycle of the explanatory notes, and I'm not going to take the court through that, but behind the second tab are the notes from January 2022, and I would like to take the court. The numbering is pretty poor because the bundle numbering is stamped over the internal page numbering, so it's difficult to see which one's reading. It's page 159 or 419, depending on which one you're looking at, and it's the beginning of Part 5, paragraph 900. Very briefly, the life cycle is that remediation contribution orders and remediation orders, as we now know them to be, don't appear until April 2022. That's the document in the next tab, but the explanatory notes there don't say anything more than the sections themselves, so there's nothing in there. So I'm looking actually at a period pre the introduction of RCOs, and it's a different provision relating to service charges, and I'll take the court to the provision itself in a minute. But these explanatory notes, therefore, do predate the Act, and I'm relying on them to show that even at that stage, before even RCOs were introduced, the concept of the property owner, the landlord, being encouraged to chase the developer already existed. So this is pre-LPI regulations, and the significance here is it's not an inter-landlord debate, which was the point of distinction my learned friend Mr. Selby relies on. This is outside of that, and one can see the machinery is this, as proposed. For section 20, if one looks at paragraph 900, the clause amends the existing section 20 consultation process for the Landlord and Tenant Act. 901, for specified remediation works, the landlord must take reasonable steps to seek other cost recovery avenues before passing on the cost to leaseholders. And the second bullet point is to ascertain whether any of the cost of remediation works may be met by a third party, and the third parties include the developer or anyone else involved in designing. And one can then go to the provision itself in the core authorities bundle, tab 4, page 46. So what I've just taken you are the explanatory notes for this section, which the section itself is in force, but the section 20D, which is the relevant provision, itself is not in force. So Schedule 8, as we know, protects leaseholders.
But we're entitled to look at material which was enacted by Parliament, whether or not it's being brought.
Indeed. And Schedule 8 obviously gave a suite of protection, but there are some leaseholders that can't use Schedule 8, a non-qualifying leaseholder, for example, or a tenant who's had to meet some level of contribution. And they get some residual protection in Section 20D. Although it's not in force yet, as I say, and Section 20D of the Landlord and Tenant Act will provide that the landlord must, and I'm reading from the bottom, 2D, take reasonable steps to ascertain whether monies may be obtained from a third party in connection with the undertaking of remedial works. And those parties include, on the next page, a claim made against the developer or designer or contractor. So the point is, before the introduction of RCOs, before the LPI regs, the concept that the developer should ultimately bear responsibility was already in the thinking. So that was the...
But it may also be relevant to look over the page at subsection 4.
I made the mistake of closing the file.
Sorry, I think.
Yes.
Where any funding of the kind in subsection 2 is obtained, the amount of the funding is to be deducted from the remediation cost and service charge. And subsection 5, there's a sanction in the case of...
Indeed, it comes off the amount that's chargeable. Yes. So that was the first point. The second point of my 4 was formally to rely on Tesco, which is now in the bundle at tab... I'm not sure which tab it is, but it's page 555, thank you.
Sorry, page
555 is the case my Lord Lord Justice Holgate referred to, and the relevant paragraph is at page 580. It's the very last paragraph of the case, paragraph 17.
Sorry, page
580. It's the very last page before the next tab. That's the Lord Hoffman point about no weight, minimal weight.
So I'll just read it. Is that the correct spelling of scholasticism?
Only a scholar will know.
Yep.
There's also page 576, letter F, G. That's where the discussion starts, and it ends up in the last paragraph.
Yes, thank you. The third point on my list was to draw to your attention the document Mr. Polly referred to yesterday, which is the BSF guidance notes, which are in the final tab, to which reference was made. It's page 618, and the relevant provision was a sotto voce exchange between my own friend Mr. Polly and I yesterday. At page 623, on page 6 of the document itself, there's a heading Fund Objectives, and it says the objectives of the Building Safety Fund are that, and then the fourth bullet point is cost recovery from those responsible for the installation is maximised. And the sotto voce exchange was that you will find that recorded in the FTT's decision at paragraph 190, because this was a document in the case, and that's Core Bundle 11, page 186. That's the third of my 4 points. And I'm also, and my own friend Mr. Polly took you to the footnote at the bottom of page 11, internal numbering, page 628. And then the fourth point was the additional point that my own friend Mr. Walsh anticipated I might make in relation to retrospectivity, and it's this. It's in connection with the Granada case, but I don't think you need to take it up. And it's this: the analysis of the legal question of retrospectivity is, of course, ultimately a question of law, but it involves the assessment of fairness, as we've seen in Sharifian and Granada itself. Fairness is obviously a balancing exercise, and the gloss that I'm inviting the court to take is that bit of the task was in this case undertaken by a specialist tribunal. So I'm picking up the point I made in ground one and using it, so to speak, as a subset of the analysis of fairness. And one can see in the exercise of fairness and balancing, the tribunal at paragraphs 75 to 78 are bringing their own expertise.
Sorry,
Paragraphs 75 to 78 of the FTT's decision. They're bringing their expertise to that question. And so I'd say it's obviously ultimately could be a matter for this court, but at least some emphasis.
When we look at retrospectivity, that's to do with interpretation.
Indeed.
I understand the concept of respect for a specialist tribunal when reviewing their exercise of discretion, but we're not dealing with that here.
No.
No. And that seems to be a rather novel position.
What I'm saying is that the considerations of the competing interests within a particular sector.
We have the benefit the views of a specialist tribunal, but I don't think we have to defer to them.
I certainly wasn't
questions of
suggesting that.
interpretation.
I certainly wasn't suggesting
No,
that.
okay, I misunderstood.
But this court, in my submission, can be assisted by
Yes,
their
yes,
expertise.
and
Put it no higher than that.
That's more nuanced.
Is that the same point Mr. Walsh made, that whether the legislation is unfair or not is tempered by the fact that you don't get an RCA automatically, but only if it's just inequitable? Or is, is it a different
It's a slight. It's just an extra gloss that I'm placing to say when you're. His point, which I also endorse, which is a larger point, which is that the whole of Section 124 is balanced with a just and equitable mechanism.
Yes.
But no, that's a separate point.
Well, that point I understand, because that goes to interpretation.
Absolutely.
But your point's a different one, and I don't think I've quite understood what it is.
That's my fault. I'm saying that in terms of the fairness of treating the provision as having such retrospective effect as it may be suggested it has, one has to look at how it would play out in real life, in the industry, with the various sectors and all the rest of it. And the high watermark of all I'm saying is that in evaluating those questions, this court has the benefit of a specialist tribunal's view.
One of the problems with this is we are interpreting a statute, not just for the parties in these cases.
No, I
There's a
certainly
whole range of factors.
absolutely, but
see
the
how
paragraphs
far-
75, 78 are looking at it in a broader way.
If they're looking at it generically,
Yeah,
that I
and
understand.
my submission, they are.
Okay.
But I'll say no more than I have.
And you're just about to sit down, so let me just query one thing. You said that tab 9 was the last tab. We actually have a tab 10. That's not something that you're taking us to.
It isn't. I think that may have come in about 25 past.
Is that
10.
Mr. Selby? Or Mr. Allison? They will get there in due course.
Yeah.
Yes, thank you very much. Mr. Selby.
Thank you, my lord. So I'll aim to stop about 12:30. And first, let me emphasise that I'm not going to repeat myself. I intend to address you on the points that have arisen over the course of the submissions that I have not already addressed in opening or to some extent in my skeleton as well. And I will do so in the order in which I made my opening: ground 1, then the sub-grounds, then ground 2. Can I just address you on the supplemental bundle that you've received overnight, so you know what's in it? You've had a bit of a taster from my learned friend, Mr. Nissen. I understand that different people might have different dividers, but let's see how we go. Tab 1, as you've heard, is the first round of explanatory notes. That's for the 5th of July 21, and you see that on the first page. The next tab, Mr. Nissen introduced to you, and that's the other round of explanatory notes, and you get the date for those at the very bottom of page 261. Can you see there's some very small, or relatively small font that says that they relate to the bill as brought from the House of Commons on 20th of January. And then the next round, to get the date, you actually need to go to the...
I'm sorry to interrupt.
I'm sorry, my lord.
That says as brought from
Yeah.
the House of Commons. Slightly different to the index. Page 1, to the bill as brought before the House of Commons in January. It had been through the House of Commons, it's on the way to the
Yes.
Lords, and this is what the Lords get, is it? Or
That question I can't answer.
Well, it has got a footnote of HL Bill 98.
yes,
Yeah. The one thing I can tell you is it must predate the round of amendments
yes.
that were 14th of February 22, which are part 5 that we know
Yeah.
about.
But we know they were introduced in the Lords.
They were introduced in the Lords, and we...
In fact, if you go to page, forgive me, 260, what these notes do, these notes relate to the building as brought from the House at the same point. I mean, it may be they were given to the House of Commons, but from this we don't know.
Yes.
Then the next tab is the explanatory notes that do say something about Part 5. You see from page 512, paragraph 1.
Yes, I see. My divider has gone in the wrong place. Yep.
The dangers of preparing bundles overnight.
Yep.
So you see paragraph 1, explanatory notes relate to the Lords Amendments to the Building Safety Bill as brought from the House of Lords on the 5th of April 22.
So, now I'm confused. Has this?
I think one of the problems is that because it's being double copied.
Yes, I suspect 511 is the last page of the previous document, and 512 is the first page of the new document.
It's Hobson's choice where you actually put the divider.
Now I follow that.
It
But
doesn't work on one.
so 511 doesn't relate to the document in the next tab. It's 512 that is the beginning of the document in the next tab. Yeah, I'm with you.
And really, just so you can see what was said in relation to RCOs and ROs, if you turn through to page 524, hopefully this isn't going to be the high point of my submissions, you'll see basically very little was said at paragraph 75 and 76. So then just introducing the bundle, there are some documents I'll come back to. The next divider you should have page 539, section 2 of the Contract Rights of Third Parties Act. You'll remember you've asked us about waiver of third party rights, and I will address you on this when I come to ground 2. Then I'm going to come back on what are in my file, tabs 5 and 6, but you'll see it's CPR 54.1 and Wednesbury. Then behind tab 7, as you've already seen, is Tesco. Now, I don't know if you go to page 581, I don't know if it's a separate tab on your file or not. It's not on mine.
It is. This is Chartbrook.
Yes.
My lord, it's familiar.
Yes, I noticed that as well, but you beat me to it, so yes. So page 581's Chartbrook. That's because, of course, Mr. Polly raised in his submissions the issue of correcting what's called obvious mistakes in contracts by construction. I thought you'd better have an authority on that point. And again, I'll come on to that when we come to ground 1.9. And then finally, you've got the building, well, not finally, you've got the Building Safety Fund guidance. And I will just take you through some of those pages because they pick up a few of the points that have come up, and I'll do that next. But then finally, tab 10 is an authority that actually relates to Adriatic, and that's been inserted by, I believe, my learned friend, Mr. Allison. Yeah. So just on those guidance notes, Lord Justice Nugee as well, remember, he asked about what's the scope of the fund and what does it cover. And so I'll pick that up as well, and there have been questions about the date of the fund opening and so on. So if I could just give you some references. Page 622, we see at the top that the Building Safety Fund was announced in the budget of the 11th of March 2020. And then if you turn over the page to 623, you see the section that my learned friend Mr. Nissen talked to, fund objectives, but just above that fund overview, second paragraph, this fund will cover all reasonable eligible costs for the works required to address life safety fire risks associated with cladding. That's the point on scope, which I will take you to a passage that develops on high-rise residential buildings in England. And then on to page 627. You then see a fuller explanation of what the fund will fund. And you see the paragraph just above the bullet points. You see again this idea for both these applications. We cover a wide range of direct project costs to address the fire safety risks posed by unsafe cladding systems. Then it breaks them down. And then if you could just go to the next page, the bullet at the top, they say there that they fund legal costs incurred in connection with a successful cost recovery action. And you'll remember my learned friend referred to footnote 9. That footnote 9 attaches to this bullet, and you'll see footnote 9 at the bottom. That explains that essentially they fund the legal costs by allowing you to deduct them from your successful claims. So it's an indirect funding rather than a provision of money up front to pursue claims. And then you see also on page 628 what we will not fund. So just to develop that point about it only relating to unsafe cladding, it talks about not funding, the first paragraph, not funding any works that go beyond the recommended action to address the fire safety risks posed by unsafe cladding systems, even where these works may be planned to be undertaken at the same time. I don't know if it'll help you, Lords, but for me to explain what an FRAEW is.
I wouldn't mind just seeing, it must be defined in this document, I assume.
The F is a fire, presumably.
Let me tell you in as quick terms as I can.
It
Fire
may
risk,
not be defined in this document.
it's a fire risk assessment for external walls. And that can recommend that will recommend action to rectify risks identified.
Yep.
And so what it can do is rather than take off the cladding, for example, it can say install sprinkler systems. And if that's what the FRAEW recommends, you can recover from the fund the cost of the sprinkler systems, even though that's not work per se to the external walls. Because it's all about risk management. So that might help you if you spend more time reading this document. I'm not suggesting that you should, but then just developing that point about what's not covered, you see the second round of bullet points, examples of further circumstances where we will not provide funding where an FRAEW has not been undertaken. And it gives an example of other structural works which are not directly related to the remediation of cladding systems.
It also says it won't cover interim measures, such as waking watches, which might cut across what you just said about sprinklers.
Well, the sprinklers aren't an interim measure in the example.
The sprinklers are a permanent solution.
Yes.
They're a form of mitigation.
It's a yes.
But on a permanent basis.
Yes, it's a risk-based approach to rectification. So, and then the final point I should just take you to, because it will feed into your reading of the grant funding agreement, is it starts at page 632, and I'm just orientating you in this document. You see at the bottom there's a heading cost recovery.
So that's page
632, my lord.
Sorry.
So I'm not asking you to read that paragraph, but if you then turn over the page, you get a few more paragraphs of that section. And then if you read the second and third paragraphs, excuse me, you'll see what it explains is that the obligations on the recipient of funding.
This is beginning however you are required onwards.
Yes.
Yes.
So you see the first of the two paragraphs I've asked you to read dovetails in with what is clause 5.4 of the grant funding agreement. And for the second paragraph, you'll note that what it advertises, of course, is the extended limitation period under the Defective Premises Act.
It's the next paragraph also relevant, where you do successfully recover.
Well, that's part of the clause 5.4 process, but yes. And then, this, in broad summaries, as a broad submission, is a broad summary of the clause 5.4 obligations. So that's my whistle-stop tour through the supplemental folder. It's quite large, but it was deliberately so that you've just got all the extras in one place. Yeah. So
while we're thinking about what this says about 5.4,
yes,
is it part of your case that the FTT was wrong to say that 5.4 covered the RCOs in this case?
No.
No, I didn't think it was.
No. I think I have to accept that in an appropriate case, an RCO can be a reasonable remedy to pursue. I think you'd shout at me if I suggested otherwise, to be blunt. So I come on to the submissions that apply to ground one generally. First one relates to Tesco. And you've already been taken to the final paragraph by my learned friend, and I think my Lord Justice Holgate identified the other particularly relevant paragraphs. I don't know if you would like to just see them for yourselves, but
We should look at the earlier one, which...
Yeah, so it's tab 7 of my bundle. It's page 576 under the heading 13.
Yeah. Should we just read that?
Yes. And just for your note, you don't need to look at it now. There was also something from Lord Keith who said something similar, and there's a sidelined paragraph at page 560. And what I say about Tesco is it's very clear that this decision relates to the challenge of a public body, namely a planning authority, the decision of a planning authority by way of judicial review. And as we know from CPR 54.1, which I've included in the bundle if you need it, a claim for judicial review is a review of the lawfulness of a public body's decision. And in my submission, a judicial review challenge is different to what we have before this court today, which is an appeal from a judicial decision. And if I may, can I just take you to two authorities that deal with that? The first is Wednesbury itself, so that's at tab 6 of the new bundle. And bundle pagination, page 548. And you should see that there's a sidelined paragraph at the top, or part of a paragraph. Courts must always, I think, remember, first, we're dealing with not a judicial act, but an executive act, and so on. But then can I also take you to the authority that's actually in our authorities bundle, G and G?
The references
to G and G.
G and G.
Yes. I think, just trying to be tidy, that the extra bundle can go away for a little bit. So G and G is in Triathlon Authorities 1, tab 4. So, can I just check for pagination purposes? My copy of G and G starts at page 135.
There's mine.
I've got one starting at 54, but I think I also have one at 135.
Do you mind going to 135, my lord?
Well, I've marked up the earlier one.
Ah,
I got to it first, but if you tell me the page
we'll
number,
work on the internal page numbering.
yes, that would be helpful.
So, internal page 652 or bundle page 140, please. If I could just give you some references to read, and then I'll make my submission. So, on this page, towards the bottom, under paragraph side letter F and G, we see a quote from Lord Scarman in B&W, and you see there that he said, at the end of the day, if you could read that quote.
Yes.
And then you see the paragraph, please, that starts, the same principles expressed in other words.
And how far would you like us to read?
Just before it says Brown LJ, and you see how it's... So there's the reference to insufficient weight. And then if you could turn over the page, there's another quote from a judgment from Lord Justice Bridge at B. You see directly in line with B, it says, on the view I take, his error was in the balancing exercise. He either gave too little weight to the factors favourable or too much weight to the factors adverse to the father's claim that he should retain care. And then in the context of difference between a judicial appeal from a judicial decision and a JR challenge, please could you read the paragraph that starts at letter E, where it says the decision in re F.
Sorry, I'm not with you. Which page?
I'm sorry,
page.
my lord.
Same page. Yes, I've got it.
Yes.
Thank you.
653.
Down to.
If you could just read that whole paragraph.
Thank you.
And then just for the, I'll give you a reference, but I'm not going to give you the luxury of reading now. But it's the same point. Similar propositions come out of Lord Bridges' speech. Final page of that judgment, so it's 656 internal or bundle page 144. But if you just read the whole of Lord Bridges' judgment, it's less than a page. He makes similar points to those that I've taken you to in support of these two submissions. Weight is something you can consider on this appeal. The judicial review authorities in my submission are not applicable to this case.
There are two issues. One is the correct approach for this court on
Yes.
appeal.
Yes.
The other is how you interpret what the tribunal said.
Yes.
And all that Tesco goes to is that if it says, no, we give no weight to something, rightly or wrongly,
Yes.
they're not expressing a view on relevance. That was the reason for referring to Tesco.
I can see that point, my lord. But if
That related to a submission you made in opening.
yes, but of course you you can take into account whether due weight has been given on this appeal. My submission.
Can I just explore it a little bit?
Yes.
This case, G&G, is a case, an appeal from a judicial decision in the court system, where the appeal is not constrained. We're hearing an appeal from the upper, well, technically from the upper tribunal, which is governed by the Tribunal Courts Enforcement Act. The appeal only lies on the point of law. So is there a narrower ambit when we're deciding whether the FTT erred in law from what a court could do if it was simply exercising an open-ended appeal against a discretion? And I think that Lord Justice Lewison said something like that in one of the cases we were shown now a couple of days ago.
My lord, I completely understand your question. I don't want to answer it on the hoof by way of reply because there is the road to all sorts of problems. Can I take that away as a piece of homework? And I think the best thing to do is for my side to do the necessary research and try and produce something that can be agreed, if possible, as to approach, at least on that particular question. And if not, we'll at least provide a written note sometime next week.
I think it's a matter for the presider.
Yeah.
I'm not unhappy about that. I'm a bit unhappy about the idea that it's sometime next week.
No, we can have a precise date, of course.
I quite see it's not going to be today.
Yeah.
And I know that you've all been heavily committed this week. But
My lord, can I ask for close of play Wednesday?
that seems rather a long way away. I mean, there are two potential stages. There's the production of the note,
Yes.
and there's the attempt to agree that with the
Yes.
other parties. Maybe in reality, I can only put a deadline on the ultimate note, whether it's agreed or unagreed.
Yes.
But I think it would be helpful, at least, if it were available by 10 a.m. on Wednesday. Let me just see whether that seems possible. 10 a.m. on Wednesday.
My lord, that's what we will do. Well, I can't commit my, but that's what we will seek to do.
If they haven't agreed by 10 a.m. on
We'll
Wednesday,
submit
then
it
we'll
as an
take what you've got.
Yes. So that's what I have to say on.
Just on appeal on a point of law, there must be some authority dealing with the 2007 Act, but it's an expression which goes back many, many years.
Quite.
Lord Denning dealt with it, for example, in Ashbridge in 1965. It happened to be, I apologise for the fact that it was a planning case, but or related. And that analysis has been repeated in many cases since. And you see it in Edwards and Bairstow, for example.
Well, it was Edwards and Bairstow that I had in mind, which is obviously an appeal from a tax case. But again, it's limited to points of law. But that does enable you to reopen a decision on the facts, but only in very limited circumstances. So I'm not expecting an answer.
No, I'm
that's
listening.
the scope of the question.
Yes, thank you. I'm listening, and my junior is no doubt frantically noting. Like I say, for obvious reasons, I don't want to comment when I can't give you a proper answer.
Certainly, I can see that in looking for an answer, it's relevant to look at how far appeals on questions of fact
Yes.
have been said to involve issues of law.
Yeah.
Yep.
At least for my benefit, I'm now moving on. So just another general point on review of the exercise of discretion. You'll remember that Mr. Nissen took you through the various authorities that we do have in the bundle concerning when an appeal court might interfere with the lower court's exercise of discretion. For example, he took you to the Financial Conduct Authority and Seiler case, which is, just for reference, at tab 20 of Authorities Bundle 2. That was a case to an Upper Tribunal's, that was an appeal to an Upper Tribunal's decision in respect of the costs of the hearing. And one of the themes that you get from the cases is a particular need for restraint where the trial judge possessed an advantage, for example, by being immersed in all the angles of the case, which is a particular issue where, as was the case in Seiler, the court is reviewing a decision in respect of a costs award, which can only be made where a party acted unreasonably in the conduct of the proceedings. You, of course, have heard submissions about the FTT being a specialist tribunal, but I would merely observe this, that other than I would simply observe that other than the relevance of the specialist tribunal, nobody has said that this court is in the sort of position in which the Court of Appeal found itself in Seiler. This is not one of those cases in my submission where the trial judges possessed a particular advantage over the appeal court. You have heard in my submission and seen all angles of the case, both in the submissions which you have received and from the detailed recitation of the facts contained in the judgment. Next topic, you heard some relates to the orders.
Just before you move on, that was the case I was referring to. Lord Justice Lewison's judgment, which is right at the end, is very short. It does cross-refer to Edwards and Bairstow on this very point.
Right.
How do you interfere with an evaluative judgment when you are appealing the quantity?
Thank you. You'll remember Mr. Polly addressed you on the actual RCOs that have been made in this case. And you'll remember that he took you to paragraph 4, and if you need to look at it, it's tab 12 of the core bundle, page 211. And he pointed out that paragraph 4 of the RCOs does not just cover the £16 million that is already funded, but also, and the phrase is further or other reasonable amounts as are incurred. And so he said it's not enough to say that the work's funded, because this order covers unfunded work as well. My first point on that submission is this. If the concern is that the BSF funding is inadequate, and that is the only concern, then in my submission the RCOs are disproportionate. You don't need an order for the payment of £16 million. All you need is an order that provides that my clients shall meet any funding shortfall. And my second point is that the reason for that provision was because Triathlon was saying that there would be a shortfall, or that there was a real risk of a shortfall. And that was a position which was considered by the tribunal and is not challenged. Can I ask you please to look at the judgment, core bundle, tab 11, page 190.
I beg your pardon, can you give me the reference?
Yes, of course. Tab 11, page 190.
Thank you.
I'm sorry, we're in the decision, aren't we?
Yes.
Yes. Did you give us a paragraph number?
I'm about to. It looks like you're ready, my lord. So it's paragraphs 213 to 214, where they consider the approach of the Building Safety Fund to the provision of further funding for extras in the context of a submission by my learned friend, where he identified a potential shortfall of £4.74 million.
Yep.
So that's their consideration, and of course, what follows next is paragraph 215 over the page, which is the paragraph I relied upon in opening. Specifically, the final sentence, if I can just ask you to read that for present purposes to refresh your memory. With the support of the fund, there is no good reason to believe that the remedial works will founder for lack of money, whatever we decide. And just for completeness on the funding shortfall argument, they pick that up again at paragraph 268 at page 201. Where about 7 or 8 lines down, you can see 5 million as a reference point. And they say there's therefore a risk that there will be a shortfall, and it might be almost 5 million, but we think that risk is a very modest one. And you see 5 lines up from the bottom of that paragraph, they attribute little weight to the risk that the major works will not be completed if they don't make an order, but gives some weight to the possibility that there might be some uncertainty. My next point on the shortfall point is, as you will have seen from paragraph...
And led to 269, and the question, why not leave the works to be dealt with by the BCF?
Exactly.
The public purse.
Exactly.
Sorry.
No, not at all. My next point in this connection is, as you've seen from the update note at paragraph 3, Mr. Nissen's great fear of almost £5 million of shortfall has not been borne out. An extra £2.9 million has been provided, and there's a reference in the note to another £872,000 odd that was claimed but not allowed by the fund. I emphasise, when you look back at the note, I emphasise the word claimed, because I know Mr. Polly did rely on this £800,000. And the reason I emphasise it is because it couldn't obviously be justified to the Building Safety Fund. And we, on this side of the room, do not know what it relates to either. We even wrote a letter some weeks ago asking what it related to, so we could see what we could do, and we've never had an answer.
This is EVML's update note, isn't it?
Yes.
Yes.
Now, that takes me on to ground 1.1. I've only got 1 point more to say on that. And it arises out of something my learned friend said to you this morning. Remember, he took you to the Building Safety Act, and if we could look that up in the Core Authorities bundle, tab 4, page 46. And do you remember he showed you the new section 20D of the new section 20D of the Landlord and Tenant Act, and he took you to subparagraph 2b, but he ignored little a, which says that the landlord must take reasonable steps to ascertain whether any grant is payable in respect to the remediation works, and if so, to obtain the grant.
I'm sorry, I wrote down the wrong page number.
Oh, page 46, my lord.
Yeah, I wrote down 36. Thank you.
And it's
2A. Yeah,
2A of the new 20D.
thank you.
Grant funding is part of the picture.
This is a slightly odd provision for starting on the force, but we've now have seen from the legislative history this was the first iteration of Parliament's or the government's attempt to provide protection for leaseholders. And for qualifying leaseholders, you now don't need.
Yes.
So its only role now is to deal with non-qualifying leaseholders. Is that right?
Well, my understanding is this. So I just want to check. Do you mind if I just check something with my junior? Sorry. It's broader in the sense that it links to the consultation process before you carry out the work, and as part of the consultation you'll have to say what steps you've taken to recover the money or obtain grant funding in respect to the money.
And even qualifying leaseholders can in certain circumstances be liable for a certain amount of costs up to the
Yes.
cap and so on.
Yes.
Okay. Thank you.
You cite this subparagraph A for the proposition that grant funding is relevant.
Yes.
But the context in which it's relevant is it's part of a series of steps which a landlord has to
Yes.
take before going for the service charge.
Yes.
And if he doesn't try to obtain funding for fire or cladding related risks, then there may be a problem in pursuing a service charge option.
Yes.
But is there anything in the Act which brings grant funding in more generally as being a relevant factor? Here it's brought in this particular respect. For example, in relation to Section 124.
Not expressly that I'm aware of. Ground 1.2. So this is the LPI regs issue. And you'll remember that Mr. Nissen addressed you on paragraph 265 of the judgment, which features at page 200 of the core bundle. You might just want to have it open so you can remember what the paragraph is, rather than to reread it. Tab 11, page 200. And you'll remember he said there were 2 points. One was a broader policy point that you derived from the LPI regulations, on which I've got nothing to add. But then he made a second point, which was his attempt to deal with what was meant by the phrase unanswerable, which features towards the, it's the second line from the bottom. And you'll remember I made submissions on that to you. And what my learned friend sought to do was to try and diminish what was meant by the phrase by recognising that there may be disputes of fact in relation to any given notice, but submitted that that was not really the FTT's point when it used the phrase unanswerable. and what he submitted was that all that the FTT was saying was that there was a potential way that EVML can get to the trustees, I assume, without the need to prove that it's just and equitable. My Lord, understood in that way, the point is not controversial. But if that's the only point, then it's not saying anything more than the policy point already made at the beginning of paragraph 265. So I submit that you cannot read unanswerable in the way that Mr. Nissen suggested.
The word unanswerable is used in conjunction with route to recovery.
Yes. My Lord, that takes you to ground 1.3, motive and identity. And you'll remember my learned friend Mr. Polly said that a director of EVML could not have signed up to the remediation contract with Errigal unless funding was secured. Now, what he didn't tell you was when they signed up to the Errigal contract and how that fits into the chronology. And for me to explain that point, can I ask you to look at the agreed chronology?
It's 2 days before or something.
4 days before the application.
14th December.
Yes, it's page 14, tab 10, page 146 of the core bundle.
15th December.
Yes, contract agreed on the 15th of December, and then the RCOs were made on the 19th of December. So the building contract was signed before the applications were made. And so before the applications were made, the directors of EVML must have been satisfied that funding was secured.
I mean, just talking around this, they'd had 1st of June, they get confirmation that they will have pre-tender support.
Yes.
19th of October, they get pre-tender support for 2.2 million. Then, as you say, they enter into the contract on the...
So it's the 11th of August, that the approval of the pre-tender support as well.
Oh, you're quite right, sorry. You'll know much more about building contracts than I do. Can we assume that when they enter into the contract on the 15th of December, they're committing themselves beyond the money that they've already got?
Yes. And just by reference to what you see in this chronology, rather than the broader chronology, work did start shortly afterwards. There is another detail that's doesn't feature in this chronology. You see, remediation works to Block D itself started on the 20th of April 23, so before the grant funding agreement was entered into.
And we can take it, can we, that at that stage you will already be extending beyond the 2.2 million funding?
What I can tell you, which doesn't quite answer the question, is that the sequence of the work was arranged in such a way that the blocks on which work started first, from recollection, would get living blocks. And that was because Get Living had already said that they would make sure that those works were funded, irrespective of the outcome of the funding application. There was a logical sequence. So, in a roundabout way, the answer to your question is yes.
Well, I'm not sure I've understood that then. I mean, if the works proceed because you have provided comfort, then going back to your initial point, why can't the directors rely on that?
Well, they can, but that's not really my point. My point is that funding was secured. It was said by my learned friend, Mr. Polly, the applications were made at a time when funding wasn't secured, but it was, just not the building safety fund funding.
But the application is not to cover Get Living share, it's to cover Triathlon.
Yes.
And Triathlon never gave commitment to fund anything. So I haven't quite understood how the chronology works. When you sign the contract, which we can see is on the 15th of December, are you committing to work to all 5
Yes.
blocks? What was, I mean, it's not really a question for you, but
Yes.
what was the basis on which the directors felt comfortable signing a contract for whatever it was, 24 million, if part of that is not yet secured? And you say, oh, but it must have been secured, but I don't understand quite where they got the comfort from. I understand they had comfort from you for your blocks. That's not enough.
No, I understand that, my lord. I can't remember the answer to that question, or I certainly can't tell you that now.
But we should be cautious. Is this your submission? We should be cautious about assuming that when they brought the application that there was a funding gap.
Yes, yes, should be called, but yes.
But on the other hand, when one looks at the chronology, what we can see is, although the BSF has given pre-tender support, which must have given you some comfort,
Yes.
they don't confirm formally that it's been approved until February, and then it's
Yes.
not signed up until June.
Yes.
And I don't know how comfortable that would make you feel as a director. These seem
Yes.
to be factual questions we're not very well placed to assess.
No, that I understand, but I'm more addressing the submission that was made to you, which was there was at the time the application was made, there was no comfort, but actually,
Yes, I see.
This all goes, I mean, these, one would have expected, would have been matters explored before the FTT, insofar as it was relevant.
yes,
But does this sort of go back to questioning the motive of Triathlon for making the application?
Yes.
Which we looked at.
yes, exactly. That's why I'm in.
And it leads to the public purse point.
Yes.
Yes, I think I've grasped that.
Well, quite, and that, as I promised you, I will not repeat myself.
Now I'm confused because I think the TT said that your submission was that Triathlon's motivation was to obtain more money.
Well, can I come on to that? Because I have... Before I do, I just want to say this. We're still none the wiser as to why Triathlon made these applications. And I note that Mr. Nissen couldn't give an answer yesterday either. And just to answer your question, he did say that the motivation that I attribute to Triathlon was a motivation to avoid costs, and that there was nothing wrong with that. He mischaracterises my case in my submission because Triathlon had no motivation that justified the making of an order. That's my crucial point. Because the costs of the remediation works were already being avoided.
Primarily through
By-
the BSF.
Through the BSF, and also just thinking of Triathlon through the acceptance that Schedule 8, Paragraph 2 applied. And so what he now says is that the motivation for the applications for RCOs was plainly the issues within the boardroom at EVML. But all that tells you is that his clients wanted to escalate their fight with Get Living to a courtroom. It doesn't justify the making of an RCO generally, and it certainly doesn't justify the making of an RCO when the works are funded and underway. And I would also observe that nobody has suggested that RCOs were introduced to enable the FTT to act as some sort of boardroom mediation service. Mr. Nissen then addressed you on the relevance of the Secretary of State being or not being a party to the RCO applications. Again, I say that Mr. Nissen's mischaracterising my submission. My point was not that the Secretary of State should be party if the purpose of the application is to reimburse the public purse. Rather, it was to strike a contrast between Triathlon on the one hand, who still does not present itself as someone seeking to ensure that the public purse is reimbursed without delay, against someone such as the Secretary of State who could easily have done that. That's my only point. So then I come on to ground 1.4 on the public purse point. And Mr. Nissen said it was a timing question. Why wait? Why wait for the public purse to be reimbursed? And he said there'd been lamentable progress of the claim by EVML against Galliford Try. And as to that, I would make 3 observations. First, you heard Mr. Polly himself reject the allegation about a lack of progress by EVML in his oral submissions. Secondly, you've heard enough about the issues in the boardroom to allow you to draw your own conclusions about progress or otherwise with EVML's claim. And thirdly, as you've heard, SVDP and Get Living have had to take matters into their own hands and are now pursuing their own claim. I don't accept Mr. Nissen's apparent suggestion in that regard that SVDP has pursued its claim belatedly. In that connection, I should actually emphasise it's very difficult to pursue a claim without cooperation from the management company. This picks up on a point that you've heard in a different context from Mr. Polly, which was, well, the developer's best place to pursue the claims, not the management company or the tenants. There's some truth in that, but not exclusively. If you're just thinking about access to, say, contractual documents with a supply chain and documentation to what was happening during the course of the project, was this instructed, what was the design, those sorts of issues, yes, of course, that's where you'd expect the developer to have the documentation and the information. But what's most important to an RCO case or a remediation order case, and I will add, a Defective Premises Act case, it's the defects. It's the nature and extent and presence of defects. And how do you accumulate that evidence? You accumulate that evidence by site investigations and cooperation with tenants who allow you access to their flats so that you can see what's going on inside. Issues, for example, about compartmentation, or in a case that Mr. Nissen and I did, damp and mould, and water ingress and so on. That is something that the management company and the tenant are uniquely placed to provide information on. And typically, if you're acting for a developer in one of these situations, they have trouble getting the necessary access to carry out the necessary site inspections, and that needs to be arranged. So the true position, if I can put it that way, is you need cooperation from all parties to pursue claims. But actually, if you're looking at an RCO claim, for example, it's the tenant and the management company who are actually really well placed. And in that connection, regarding SVDP pursuing its claims, you'll remember that I mentioned that the claim includes for internal compartmentation defects in the blocks. And of course, that claim relies upon the necessary inspection reports, and they can only be commissioned and obtained by EVML in this context.
Do you not have rights of access as freeholder?
I couldn't tell you the answer to that, but my suspicion is it's through EVML. Yes.
So your direct contractual relationship is with EVML, isn't it?
As freeholder.
As freeholder. Yes.
Now, but just thinking about developers generally and the idea that it's all on the developer. So I'm not being specific about the facts of this case. Developers who have sold out, that they have a particular problem over and above.
Just on the last point, and I'm sorry if I'm missing something.
Yes.
Freeholder, reversion. There is a lease.
Yes. Yes.
But does it and you're recovering service charges as freeholder or not?
EVML receives.
EVML. Okay. So there's
Mr.
no
Polly
repairing
explained.
obligation on the freeholder. Okay.
No.
You can see why. Yeah. Thank you.
So, Mr. Nissen sought to contend that the whole purpose of the statutory scheme is to make developers pay first and then pursue their claims against their supply chain separately. That, of course, as I accepted in opening, is just and equitable where there are remedial works that need to be carried out and are unfunded. But as I have said, that is not just and equitable in this case, where the works were funded and underway, and leaseholders were not being required to foot the bill. And in that connection, one point of detail that I should clarify is that in support of this submission, Mr. Nissen said that the Building Safety Act had introduced what he described as enhanced rights. And the first he referred to as the new rights under Section 2A of the Defective Premises Act for converted buildings. You'll remember he said that Section 1 of the Defective Premises Act correctly only relates to new build developments or major conversions. So if you had an office block that you converted to a block of flats, but the duty under Section 1 would not apply to a building such as Grenfell, where it was an existing block of flats and they just put new external insulation and cladding panels on it. And so the new Section 2A relates to those types of projects. But importantly, the new Section 2A rights do not apply retrospectively. And I should just show you the reference to that. So Section 2A is brought in by Section 134 of the Building Safety Act, and that's in the Core Authorities Bundle, tab 4, page 49. And the reference that I'd just like you to see is over the page at page 50. At the very end, the subparagraph 2, the amendment made by this section applies in relation to work completed after the coming into force of this section. The only enhanced rights provided by the Building Safety Act that are retrospective are the rights against cladding product manufacturers under Section 149 of the Act. But those rights aren't even given to developers. If I can just explain that point, if you could just turn through to page 57, please. That's where you see Section 149. Subsection 6. You see that the person who's liable is liable to pay damages to a person with a relevant interest. And that term is defined at page 53.
Sorry.
Section 147, my lord.
147.
And you see relevant interest is defined as having a legal or equitable interest in the building or a dwelling contained in the building.
That would in fact apply to you because you have a beneficial interest in the freehold.
Yes.
SVDP.
Yes.
But your point is that
But it
you have to
wouldn't-
look at the legislation more widely. It's not
Yes.
just your case.
So the developers who no longer have So in my submission, the only real enhancement for developers is that claims under the DPA now have a 30-year limitation period. And of course, that only relates to new build property, not Grenfell type refurbishment, if I can put it that way. And just in case you're interested, even in that connection, there is a case currently before the Supreme Court as to whether developers can pursue claims under the DPA. And that's a case called BDW Trading and URS Corporation. You might have heard reference to it in the context of retrospective. It's one of those cases that has a whole smorgasbord of issues being argued. Then you'll remember that Mr. Nissen made his, as I call it, topsy-turvy submission and said that the existence of the grant funding agreement is actually the reason to make the RCO, not the reason not to make an RCO. I don't accept that at all. First, it ignores ground 1.9, which I'll come back to, the breach point. Secondly, the grant funding agreement cannot determine the outcome of these applications in the way that my learned friend suggests. And the reason I say that is if you think about it, if I, and I'm not saying me as SVGP, if I apply for an RCO, sorry, if you make the RCO, then of course it will be said that the obligations under clause 5.4 have been complied with. There's an order for payment of money done. But if you decline to make an RCO, that would not mean that EVML is in breach of clause 5.4 either. The obligation is to pursue remedies, not to successfully pursue remedies. And what's more, if the tribunal were to make either of the orders that I propose should have been made, clause 5.4 would have been complied with also. If, for example, you order payment after the conclusion of the Galliford trial proceedings, how can DLUC complain about that? And furthermore, there was no finding below that EVML had not been taking reasonable endeavours to pursue its remedies in accordance with clause 5.4. And be under no illusions, the BSF knows all about SVDP's connection with Get Living. And to make that good, I should take you probably to the one document in the supplemental bundle you haven't seen, or I'm not saying not seen, not been taken to. And that's tab E2 at page 182. Now you should see that that's a covering email dated the 21st of April 2023. I'm showing you the email first to anchor you in the chronology. It's before the grant funding agreement's entered into. And you can see it's an email to the directors of EVML, which records that the attached document has been updated in line with the agreement reached by the board. So the board of EVML agreed the document, and you see over the page at 183, it's a document called the Building Safety Fund Cost Recovery Questionnaire. So that document had to be filled in as part of the application for funding before the grant funding agreement could be concluded. And if I could ask you please to turn through to page is 4 of 8, bundle page 186, page 4 of 8 internally within the document. You see section 5, under a heading, information about the companies involved in the installation of the unsafe cladding system. And then in the left-hand column, it asks in bold the names of the companies responsible for the installation of the unsafe cladding, and you see including the third bullet down, the developer. And then you see the completed information, second paragraph, well, first and second paragraph, the first 3 paragraphs relate to the Galliford Tri, the contractor, and then you see the next paragraph starting East Village explains there about SVDP as developer and so on, and then over the page at the top it explains how it's a framework agreement, and each plot's carried out by separate development agreements between SVDP as developer and Triathlon Homes as tenant. And then if I can just ask you to look at the numbered paragraphs 1 and 2 within that box. You see, as per publicly available latest annual report, Get Living, SVDP and EVML are both subsidiaries of Get Living PLC. And then it explains that how EVML is a joint venture with Get Living holding 58% of the voting rights. So it's all very clear. Supplemental bundle can go away. The next point taken against me by Mr. Nissan was that QDD Athletes Village compromised its rights against the ODA in January 2020 when there was knowledge of cladding defects in East Village. And you'll remember he took you to a paragraph in the judgment that I will come back to. But the starting, it's important to see the paragraphs. Bundle page, core bundle, tab 11, page 185 in the judgment, 187 and 188 paragraph. So 187 records the fact of the settlement, and then 188 records how the settlement concluded after Grenfell. And there's that phrase, after it was known that East Village, and I emphasise the words East Village, suffered from serious cladding problems, including the presence of ACM in some buildings, but before the extent of the problems have been identified and the full cost of remediation determined. Now, why do I emphasise the words East Village? That's because at that point there was no knowledge of fire safety defects in the blocks that are the subject of these proceedings. And again, you can see that very easily in the agreed chronology behind tab 10, page 144. You see 8th of January 2020, the settlement deed. But then you need to go down to October 2020, where you see the reference to DFC reports on chroma and kaleidoscope blocks B&E report relevant defects and indicate stay put evacuation policy no longer appropriate. And then you see that the waking watch is implemented in all blocks in November 2020. Of course, that's the immediate reaction to the discovery of problems. So that shows quite clearly that the timing's after the settlement. And developing that further over the page.
Yes, before you leave that page,
Yes.
the settlement deed was January 2020, as I understand it.
Yes.
And just above that in the chronology, November 2019, first fall survey is expected to be completed.
Yes.
So that presumably that relates to some other part of the East Village, not these blocks.
Can I check that and get back to you?
Because I'm looking for something which is consistent with what the tribunal found, that there was knowledge of some defects in the East Village, which would imply at least some blocks.
Yes, and
therefore raising the obvious question, why not others?
yes. The
Go
work.
back to 26th of February 2019. There's reference to ACM cladding
Exactly.
having been confirmed. Further information on fire safety issues N26 awaited, and our block's N26.
Yes, we're N26, and you'll remember that you've heard N2 and N7 were where ACM cladding was found. So that's what they're the separate plots where there are separate ACM issues.
But if the problem had been found somewhere in the East Village, but not N26, it couldn't
Yes.
safely be assumed that it wouldn't arise in N26.
It could not safely be.
No.
I accept that, but equally, it couldn't be assumed.
But despite that, they entered into the settlement.
No assumption can be made.
Mm.
I think is a fair way to put it, my lord.
Well, it looks from the 2019 entries as if a decision has been made to investigate everything, which is what you'd expect.
Yes.
You find it somewhere, you investigate
Yes.
everything. And by August, there's a decision to proceed with service on a priority basis. And as
Yes.
we all pointed out, the first 4 surveys were expected to be completed in November.
Yes.
There is still a valid point, isn't there? That nevertheless, despite this obvious risk that you will uncover something else, in January everything is settled.
Yes, but at that point it's only a risk, and there's no knowledge of defects. That's my point.
I see.
Thank you. It'd be a different case if, for example, the settlement was made in full knowledge that these buildings were defective.
It might also be a different case if the settlement had been made before there was any suggestion of any problem with any blocks.
Yes, quite. And I would also add, as at January 2020, the date of the settlement, the concept of RCOs or ROs had not even emerged. As we know, they were only introduced into the Building Safety Bill over 2 years later on the 14th of February 2022. And of course, that goes back to the point I made in opening about the risk landscape having changed to when risks were assumed. It was a point I made in the context of the acquisition of SVDP, it being bought with the benefit of rights and warranties against design and build contractor and so on. But finally, in this topic, Mr. Nissen took aim at my proposal that my clients only be ordered to pay following the conclusion of the Galliford trial litigation whatever the outcome of that litigation. And he said, well, what does conclusion of litigation mean? In my submission, it's a pretty standard order. We see them made in, for example, in the context of assessment of cost orders, where there's summary assessment. Sorry, there's a payment on account with detailed assessment to follow following the conclusion of the proceedings. It's well understood. If it needs to be defined, it can easily be defined. It's not really a hurdle or a proper objection in my submission. And just to conclude this ground, either order which we say would have been the right order, it is not contrary to the statutory scheme where the works are funded and underway. Ground 1.5, I have nothing to add. Ground 1.6, Mr. Nissen took a pleading point against me, saying that the points I relied upon were barely and only tangentially mentioned. I don't accept that for a minute. I think because of time, I'll just give you the references. It was made as a second point after a short adjournment, and you've got the transcript in the bundle, in the supplemental bundle, and of course I haven't noted down. It's the final tab of the supplemental bundle, page 270. I'm not asking you to do it now, but if you're minded to engage with this pleading point, you'll see that the actual exchange with the Chamber President starts at the top of page 41 of the transcript, and I was giving a number of submissions in relation to the public purse point. The point that is now ground 1.6 starts at line 4 at page 42. And what you'll see is that point was plainly before the tribunal, and to think it wasn't would ignore the fact that, for example, the third and the fourth points, which you've already heard plenty about, were made in equally brief terms. And just going to the substance, what sought to be submitted is, absent agreement by Triathlon that it would not pursue an RCO, or perhaps some kind of estoppel, the point is irrelevant that I make on this ground. In my submission, that ignores the fact that the applications to the fund were first made and pursued long before any application for an RCO was first intimated. As you saw when we looked at the chronology, £2.2 million of pre-tender support had been approved from the BSF almost 4 months before the applications were made. And as I said in opening, the remediation scheme that had been agreed because it met the BSF eligibility criteria was agreed on the 16th of June 2022, which was just before the BSA had even come into force. Now, my learned friend did rely upon a letter of the 26th of May 22, so a few weeks before the agreement of the scope of works. And what he sought to suggest by reference to that letter was that Triathlon had been completely transparent, and so there's no kick in the teeth, to use the phrase that you saw in the skeletons, at all. In my submission, the letter doesn't help Triathlon's case at all. It's still in the supplemental bundle, tab D2 at page 147. I'll try and take it shortly given the time. You'll see from the first page that it talked about the need for the scope of works to be agreed between the key stakeholders, That's obviously Triathlon and Get Living. And then you'll see, as you go through to page 149, at the bottom, the reliance on not being liable because of the provisions of Schedule 8, paragraph 2. And then you see, over the page at 150, the paragraph, second paragraph from the bottom. This was the paragraph that my learned friend took you to. I think he said that Triathlon was flexing its muscles here. But of course, even there, they're referring to the need to promptly pursue the options through the Building Safety Fund, and also pursue those responsible for delivering and guaranteeing of the original design and construction of the buildings. That's not SVDP in this context. That's Galliford Try. And the reference to that is paragraph 200 of the judgment. Can I just leave that as a note for you?
Yeah.
So, Core Bundle, tab 11, page 187, which records at this time the discussion is around pursuing recoveries from Galliford Try. And then over the page, you see the threat in the last paragraph, but it's specific performance of EVML's repair obligation or a remediation order pursuant to section 123 of the Building Safety Act. There's no mention here of an RCO, even though by this point Triathlon was plainly alive to its potential remedies under the Act. On the contrary, they were saying that if the scheme could be agreed and funding obtained, there will be no need to take formal steps. And even though the letter was addressed to EVML, you know exactly who the audience was that letter was aimed at, the Get Living directors, and therefore Get Living. On ground 1.7, the grant funding agreement terms, Mr. Nissen, I've covered a lot of that already under ground 1.4. Mr. Nissen said that there was no evidence below about the public policy factors which I drew to your attention, housing shortages and so on. In my submission, you don't need evidence of that. The public policy factors are well known, but even if they're not, they simply illustrate my point that decisions such as whether or not funding should be given are decisions entrusted to public bodies, which should not be interfered with other than through a judicial review process. I'll come back to the proper interpretation of clause 4.3.1 under ground 1.9. The reason I'll do that is because Mr. Polly called it ground 1.9. On the ground 1.8, the point about changing identity of ultimate owners, you were referred to paragraph 174 of the judgment, Core Bundle, tab 11, page 183. And this was the point about Get Living having involvement with East Village going back to 2013. And you'll remember you referred to a press release launching the flats coming to market. That is simply marketing material that was consistent with QDD, as it was then, gearing up to let the properties once ownership was acquired. And this idea of gearing up, you see from paragraphs 170 to 171 of the judgment on the preceding page, because there was a process. Once the agreement for the purchase of the SVDP was entered into, but before completion, there was a period in which QDD had various rights, such as monitoring rights in relation to the conversion of the building. And of course, they were also trying to ensure, to allow them to start the marketing as well, it would have done. So that's all that refers to. And it doesn't deal with the point which comes at the at paragraph 172 at the end, which I took to you in opening, which is that for present purposes, SVDP was sold to entirely innocent purchasers. And it also doesn't address the point that I made in opening, that SVDP was purchased with the benefit of rights against third parties, where pre-Building Safety Act, the purchaser or SVDP would have been able to pursue those rights before having to pay out for the remedial works, because everyone would have been party to one set of proceedings. So then we come back to ground 1.9, the interpretation issues we heard about the grant funding agreement. Again, Mr. Nissen didn't address the point that I made in opening when he said, but Triathlon's not party to the grant funding agreement, it doesn't affect it. And the point I made, of course, was if it's relevant that EVML has an unanswerable claim against the freeholder, the point that came in ground 1.2, it must also be relevant that Get Living has an unanswerable claim against EVML, especially when Triathlon was so instrumental in obtaining of the funding. But more substantively, we come on to Mr. Polly's submission on the grant funding agreement. Let me start by making, if I may, 3 preliminary points. The first is that Mr. Polly's submissions ably demonstrated, if I may say so, that the tribunal's finding at paragraph 273 of the judgment that my interpretation of the agreement is optimistic cannot be right, given all the mental gymnastics that Mr. Polly had to go through to make his point. Secondly, Mr. Polly's submissions that the agreement contains an obvious mistake is an entirely new point. I won't take you to it now, but see his skeleton on this issue at paragraph 63 to 66, core bundle, tab 5, page 98 to 99. And that leads to
what paragraph was that,
sorry, paragraph 63 to 66. And that leads to my third point, that it was such a new point that you didn't even have the relevant authority in the bundle chart book. But as you've seen, we've got that in the bundle. The new authority bundle. I probably don't need to remind my Lord Justice Nugee about what it says. It starts at page 581 of the authorities bundle. For present purposes, could I just ask you to go to page 592? Paragraph 14 of the judgment at the top. Near to the letter B, the house in ICS in West Bromwich emphasise we do not easily accept that people have made linguistic mistakes, particularly in formal documents. And he cites a number of cases and then said that in some cases the context and background drove a court to the conclusion that something must have gone wrong with the language. In such a case, the law did not require a court to attribute to the parties an intention which a reasonable person would not have understood them to have had. And then if you see the start of the next paragraph, it clearly requires a strong case to persuade the court that something must have gone wrong with the language. And then if you turn over to page 594, paragraph 22, that's where you get the actual test that you apply before you correct a document by construction, as opposed to rectification. And it's two conditions: has to be a clear mistake on the face of the instrument, and secondly, and often overlooked, it must be clear what correction ought to be made in order to correct the mistake. So that's the authority. Picking up on the points actually made by Mr. Polly, his first was that the funding agreement doesn't work because clause 4.3.1 is in conflict with clause 5.4.1. Shall I help you tidy a bit, because I'm conscious we might have a lot of fun. The new authorities bundle can go away. If you've got core authorities open, that can probably go away as well. For a little bit. But we need the supplemental bundle because that's where we find the grant funding agreement. And can I just address that point about conflict by reference to clause 5.4.1, because that's where you'll find the answer. So page 223. Because in my submission, the proper way to read a contract is as a composite whole, and the simple solution to Mr. Polly's suggested conflict is in the language of clause 5.4.1 itself. Because all EVML has to do under 5.4.1 is pursue reasonable remedies available to it. That's the key word, available. If clause 4.3.1d means that a claim against Get Living is not available to EVML, then EVML is not obliged to pursue Get Living under clause 5.4.1. His next point relates to clause 4.3.1d, so we should go have that open at page 218. Excuse me. And his next point was that the reference to claim only relates to claims for service charge. I submit you cannot read the clause so narrowly. Naturally construed, the word claim has a much broader meaning. Bless you.
Thank you.
But then, construed with subparagraph G, you see it can't mean that, because subparagraph G talks about the applicant shall only seek to raise a service charge payment. That's the phrase it uses in relation to service charges, raising a service charge payment. So if it was only if claim in D only related to service charge, why does it use different language? It also ignores the definition of leaseholder at page 204. Because you'll remember that talks about people being party to leases. Now, there are always at least two parties to any lease, and it's usually only one of those parties who pays a service charge. So that's what I say about it only being limited to service charge. But the flaw in that argument undermines his and Mr. Nissen's status argument. In other words, that you need to look at the status in which GL, Get Living, is party to the proceedings. I think they said you can only sue qua landlord against someone qua lease leaseholder. That's all it's saying. But I say if 4.3.1d does not apply to service charge demands only, that point must fall away. But in any event, that's not what the clause says. It makes no reference to status. Rather, it expressly refers to all leaseholders, capital L. And you'll remember, leaseholders has within that the subset of protected leaseholders, which were the qualifying leaseholders. So it's a very broad church. Not, for example, trying to protect the individual, what I generally refer to as the individual leaseholders. And in my submission, its purpose is clear. It's telling EVML to use the money it's been given by the fund to get on with the work and not bother or concern any other leaseholder, capital L. And in my submission, that has particular resonance in this case because it says to EVML to put a stop to these boardroom issues and focus on the remedial work. And
We were told this was a standard form.
yes,
Did you dispute that?
no,
So it's not tailor-made for this particular
No.
situation.
no.
Do you accept that any developer can be protected by buying a flat in the building? I don't.
I am. Can I come back to that point because I've got it on my list of points to cover here.
Yes.
But if I may, I'll just keep to the points as they arose and
Yes.
as they naturally flow, if I can put it that way. And I will also address you, just so you know, on the waiver question. The status point is also not what the definition of leaseholder, capital L, in the grant funding agreement says. Again, it refers to both parties to a lease document, not only those who are party qua tenant. So then Mr. Polly contends that the definition of control at paragraph 204 must be a mistake. And what he says, if I've understood him correctly, is you have to put a red line through the 3 lines where it defines control. And you must also have to put a red line through subparagraph B in the definition of leaseholder. In my submission, that is a very bold submission, not borne out by a proper construction of the agreement, not obvious, not apparent, and it's certainly not obvious in my submission that that is the right correction to make, or what corrections should be made. And you'll remember that Mr. Polly sought to develop his submission by reference to other provisions of the GFA. They didn't take the point much further, so I won't dwell on them. But for example, he thought that only individual leaseholders have an interest in talking to the press. In my submission, that's just wrong. Everyone is entitled to express their side of the debate. And for example, not uncommon in these situations where you have leaseholder groups complaining to the press that the landlord, the developer, whoever, is not getting on with the work. Well, why shouldn't the landlord or the developer want to put their side of the
I mean, the question might be slightly different. Why should the Secretary of State be concerned to protect developers in that way? One can quite see why they might want to leave tenants open to say what they wanted. It's not so obvious that the Secretary of State would have wanted to make special provision for developers.
No. When you read the clauses, it's more about protecting the Secretary of State and what's said about the Secretary of State in my submission. It's not really about protecting leaseholders. I suppose if you think about it from just optics, public perception, it might be read as saying, well, you're trying to stop the people from speaking. So if it's written there, they can see, no, don't need to worry about it. But what is interesting about this clause is it comes back to the status point. If you could look back at clause 10 at page 230, the last sentence of clause 10, this clause doesn't apply to leaseholders who remain free to communicate with the press in a personal capacity about the project. That language, in a personal capacity. So this contract does use language of status, but it doesn't use it in 4.3.1d. So, my lord, let me now address your question. What I call the mischief submission. In other words, anyone, you just need to buy one flat and you're safe. In my submission, it's a false alarm. I say that for a number of reasons. It's not any real protection. At its highest, it only protects the developer or the contractor or whoever might be in the firing line from a claim by the party who has obtained the funding. It doesn't protect it from any claim by other parties who have contractual or Defective Premises Act rights. And remember, the Defective Premises Act rights are very broad. Anyone with a legal or equitable interest in the dwelling.
But it's the person who's obtained funding who's going to be doing the works. So it's they who are going to be bearing the costs. So
yes.
You would expect they're the ones with the substantial claim. But just because you've got an interest in the building, if you're not spending any money, you don't.
Well, a landlord could still pursue a claim and could pursue the claim for the full remedial cost. Of course, it would be set against it, but you've got the money from the Building Safety Fund. But that would be raised inter alias acta. And it could be said, but you're not incurring the costs, but they could still pursue a full remedy because they've got a defective building, and what it would be, and what they would just have to, probably what they would have to do is ensure that they would undertake that the fund is made whole. But it can be done. And finally, and this is a point I said I would deal with, the possibility that the Secretary of State could waive the obligation in these circumstances.
Mr. Polly didn't encourage the idea that was possible.
No, I know, and I'm not going to help myself here, but I have to be honest. So
it might be.
While you've got the funding agreement open, you need to go to clause 26. I'm sorry, no one's taken you to that. It's page 237. Now, actually, it's a good example of an obvious typo that the court would correct by construction. Because you see it says, save as specified in clause 4.3.1F. That must be D. But it says no third-party rights in the first sentence. But it also says in the second half of the sentence, nor will the consent of any person who has not so executed this agreement be needed to make any modification, amendment, variation, or release of its terms.
Yes, I see.
And the reason that's important is when you come back to the Third Party Rights Act, Section 2.
Yeah.
Because Section 2 says, not without the consent. Sorry, so it's tab 4 of the New Authorities Bundle. Section 2.1 of the Act. It's just the end of subsection 1 before you get to APC. It says without his consent.
Yes, I see.
So the clause 26 modifies that.
Does it? 'Cause is the whole of the first sentence governed by save as specified in clause 4.3.1?
Ah, you're quite right, my lord. That's what happens when you look at these agreements overnight.
Well, we haven't looked at it
Yeah.
before at all.
Yeah, no, quite right, quite right. Hang on, let me just go back to D.
But then maybe the contract provides for it. You don't get into this at all.
Yes.
Yeah,
Because it's not a question of varying a contract, it's
Yes.
just something that the contract provides for.
yes. I think I'd just better leave it as there's the relevant provisions. But perhaps I should put it this way: waiver could be an answer to that
Yes.
problem. And all I would remind you in this case is that there's been no waiver by the Secretary of State of the obligation under 4.3.1d, nor any suggestion of a waiver. It'd be entirely speculative that there would be a waiver, and I would say if there was a waiver now, that would be highly relevant in any event to just and equitable. I've got to do ground 2. I'll do that as quickly. I'm sorry I've overrun. Let me deal with it quickly.
Yeah.
In the context of ground 1.2, you'll remember Mr. Nissen, when addressing you on the explanatory notes and the lack of reasoning in those notes, stated that if the reasoning is so obvious, it doesn't need to be spelt out. Well, I would simply reply that if the reasoning is so obvious, it shouldn't be necessary to resort to the explanatory notes. But then we come to the extent of retrospectivity. What Mr. Nissen focused on when addressing you on extent of retrospectivity was the facts of this case and described it merely as a package of facts at one end of the sliding scale. But in my submission, that's not the right way to test this provision, because you need to consider all the ways in which this provision could be applied, because there's no way to apply the relevant guidance in such a way that it's retrospective in some respects and applies to one package of facts, but not to a different package of facts. It's either retrospective for everywhere on the scale or it's not. And actually, Mr. Walsh gave a very similar example to mine of how the Act, Section 124, can operate retrospectively to a completed transaction. He went further. He identified tenants who pay for remedial work in 2018, 2019. They're found liable to pay in 2018, 2019. They pay before the Act came into force. And I think he even referred to the potential that they could have a judgment against them in 2018, 2019 to meet their service charge obligation. That we say is true retrospectivity in the Wilson and First County sense. In fact, it's very similar. It's a very similar situation to Wilson and First County, because in that case, it was all about the Human Rights Act not coming into force until after the first instance decision, but before the case was heard by the Court of Appeal. And the primary point made by my learned friends, Mr. Nissen and Mr. Walsh, is really that the purpose of the Act to save leaseholders from shouldering the burden makes the retrospective interpretation obvious. They emphasise it's the purpose that makes their interpretation obvious. But they didn't really address you on why that purpose makes the interpretation contended for is so obvious. As I said, there was still plenty of buildings that needed fixing after June 22. And also, leaseholders were given the remedy under the Defective Premises Act, certainly to recover their costs before June 22. And I ask rhetorically, what is it that makes it so obvious that Parliament intended that leaseholders, and I should add other interested parties, should have a retrospective claim under Section 124 also? And the answer that they seek to give you is that litigation in the Technology and Construction Court is deeply unattractive. Now, first point I would say about that is the reality is, if you're an individual leaseholder, no litigation is attractive, whether that's in the FTT, the County Court, or the High Court. I can say that I even remember reading an interview with Mr. Battish, whose case appears in the Core Authorities bundle at tab 7, in which he said how he found the whole process before the FTT, let me put it this way, not particularly enjoyable. And what's said is, well, proceedings in the High Court or TCC are very expensive. Well, it's not the case that proceedings in the FTT are particularly cheap.
It is normally a cost-free environment.
It's cost-free.
Each
party bears their own costs.
Your costs.
Yes, exactly. Unless there's unreasonable behaviour.
Yeah.
But even that, it isn't an answer, and I'm going to develop that. But first, I don't accept for a minute that the TCC is so unattractive, or if I can put it this way, any part of the court is so unattractive. And I can imagine that if Lord Justice Coulson were on the panel, he'd be fuming at such a submission. He always takes pride about the TCC being at the vanguard of civil procedure. But it does, the real point, not the joke, is that the submission ignores the panoply of case management techniques available under the CPR. Remember, if the claim is of modest value, your fire doors where you've made a contribution of £10,000 or less, say, the claim can be pursued in the small claims track, which, like the FTT, is generally a jurisdiction where the parties bear their own costs. Or the claim could be pursued in the fast track, which has controls on costs. Even in the multi-track, there is the shorter and flexible trial scheme and power to order separate trials. So if, for example, you were concerned as a case managing judge excuse me, about leaseholders having to carry multi-party proceedings, there is an option to argue that the leaseholder claim is separately tried, or separately case managed to all the Part 20 claims. There are also provisions for cost capping orders and so on. It also ignores the fact that there are many parties who want to be able to recover their costs from the other side. Or they want to be able to conduct multi-party claims, either to avoid the multiplicity of actions, or because there might be concerns about the solvency of individual targets, including their associates. But I'd also pick up on a point that Mr. Polly made. He explained eloquently why a management company would want to be protected from retrospective claims under paragraph 10 of Schedule 8. He then sought to suggest that a claim against him under Section 124 would be more desirable. But in my submission, that misses the point. If he's the landlord or the management company that's not the developer, then there's no claim against him at all under the DPA. So he's got no exposure at all under the DPA, where he's got exposure to retrospective claims under Section 124. So from the point of view of the innocent landlord or management company who's being asked to pay back monies that it has already received, surely the most attractive solution to the retrospectivity argument is actually my solution, which is that such claims should be pursued against only those who were at fault. And what Mr. Nissen tried to do was identify a situation where a leaseholder is riding two horses, in the sense that they have claims for costs incurred before 28th of June and costs incurred after. But in that situation, the answer is, well, you go under the DPA for everything. I'm nearly there. Regarding sections 135 and 149 of the Act, Mr. Nissen drew a distinction between creating a new cause of action, I think Mr. Walsh did as well, and existing rights. That section 124 creates new rights, and in any event, in my submission, it's a very fine distinction, because in either case, you're giving someone the right to pursue claims that they otherwise did not have. And it also doesn't explain the overriding point that the Act is much clearer on retrospectivity when that is what when retrospectivity is what is intended. But finally, 2 points arising out of what Mr. Walsh said this morning. First was that he said that the FTT has always been able to revisit completed transactions. I addressed you on that point in oral submissions. If you want me to remind you of the answer to that, it's very simply never in relation to payments that were validly made at the time. And then final point was he referred to just and equitable guardrail and saying that lost documents might be an example. It's not much of an example, especially if you're thinking of a claim under Section 124. What drives the claim under Section 124? The relevant defects. The existence of relevant defects does not depend on historic documents. It relies upon the here and the now. And my Lord, again with apologies for delay, and those are my submissions.
Thank you very much. So sorry, Mr. Polly.
My Lord, just very briefly, a factual issue arose during my learned friend's submissions to do with comfort. And you heard my learned friend talk about the structure in which the blocks were being constructed. Now, I've conferred very briefly with my learned friend, Mr. Nissen. I didn't want to interrupt my learned friend, Mr. Selby, so I haven't chatted to him at all about this yet. It may be that we'll try and sort it out over lunch. I
think that would be the best thing.
Yes.
Mr. Loveday.
Yes, I think it's me and Mr. Allison on next.
What I've got in mind, following the pattern that we get normally in a case, is Mr. Allison has a go, you have a chance to reply, Mr. Allison gets the last word.
Right, okay, well...
Were you envisaging a different approach?
Well, we thought we were only going to get half an hour each, and that was it.
Half an hour each sounds good. So who thought they were going first?
I was more than happy for Mr. Allison to go last. I don't mind.
If you're both happy, then let's do that. I think since Mr. Allison is appellant, he is entitled to the last word.
Yes. The only other thing I'd mention is that both of us have tentatively produce some speaking notes, which may at least avoid you having to refer to cross-reference.
Yes.
To cross-references. I think I'd like to just update mine a little bit in the light of things that were said this morning. So I'm likely to hand it in at the end of the short adjournment.
Yes. Mr. Allison, are you in a similar position or?
My preference would be we don't hand anything up, because it can only cause difficulties if the note doesn't then reflect what's being said.
Well, that's entirely up to you. I'm not stopping Mr. Loveday handing up something, but neither am I saying that you should hand up anything.
I'm acutely conscious that it can be it can appear very unfair if one is bounced into somebody's speaking notes being produced. But I'm in your hands. I could hand them in after I finish.
I think that might be the worst of all worlds. I think I'm more relaxed about this than some people are. I slightly feel if the speaking note is only recording what could be said anyway, there's no inherent unfairness in it. I think unless Mr. Allison has any particular objection, I would be content for you to hand in your speaking notes at 2 o'clock. Should it turn out that that causes Mr. Allison any problem, then we can work out where that takes us.
I will be modifying my position, if I can put it that, or at least commenting on the developments in triathlon that I say will affect the approach. So I could understand Mr. Allison wouldn't want to be commenting on something before you've heard from me. But I am completely in your hands.
And are you will have done your updating in the next 55 minutes or maybe 1 hour. Will you be content to give Mr. Allison a copy of the updated version significantly before we resume? So that he has a chance to read it before he's thrown into your oral submissions to which he will have to reply.
Yes, absolutely. I can give him the latest draft now.
One of the difficulties, I also have a speaking note which I could hand up, but there's zero chance of that being updated if I receive this note just before 2 o'clock. We're sort of just left with a slight inequality.
Why don't we do it this way? We'll both hand up our current versions of our speaking notes at the moment and take you through any minor changes to them that are necessary in oral argument.
Mr. Allison. There is no obligation on anybody to provide us with a speaking note. Mr. Loveday evidently would like to give us one, and I can't see any particular objection to that. Can you see a particular objection to that?
Depends how far it mirrors what he says. Well, I'm not going to cause a great difficulty with it. It just creates a difficult position because I can't update mine having heard him. Because mine would then be produced afterwards, which is then unfair on Mr. Loveday, so we go around in circles.
I'm not quite sure I follow this, because if we had no speaking notes, Mr. Loveday would make his submissions, you would hear what he had to say, you would have a chance to respond.
Yeah.
Were you to produce a speaking note, you would have done very well if you had managed to adapt your speaking note to what had been said orally in the previous half an hour.
Yes, but I'm now told this.
Now, I'm not quite sure that I do follow the problem.
Mr. Loveday's submissions, we're told, are not necessarily going to be reflected in his speaking note because he's going to hand up the version that he hasn't yet changed.
There are literally, the only changes I was proposing to make were to take out a few typos and to add in a reference to something that Mr. Selby said, I think, and Mr. Walsh.
I think if Mr. Loveday is content to provide his version now, it's a matter for you what you do with it. But you will have a chance, should you wish, to see what is being said so far, and then the final version will be provided in time for us to resume. And we will resume at 2:05.